but I could. Okay. I guess that meant we're proceeding. The recording is going. Hi, good morning, everyone. My name is Jack Covenier. I'm the co-chair of the Whatcom County Incarceration Prevention Reduction Task Force, also acting as the council. Before we proceed further, part of our process here is to read this land acknowledgement statement. So we acknowledge that we are gathered on the traditional and unceded territory of the Lummi, Nooksack, Samish, and Semiahmoo people who have cared for and tended this land since time immemorial. Truth and acknowledgement are critical to building mutual respect and connection across all barriers of heritage and difference. So we begin this effort to acknowledge what has been buried by honoring the truth. We pay respect to their elders, past and present, and please take a moment to consider the many legacies of violence, displacement, migration, and settlement that bring us together here today. And please join us in uncovering such truths at any and all public events. So shortly, we're going to dive in. We've got a fairly robust agenda. Our council, Representative Councilman Barry Buchanan, will be taking on the first couple of topics. I believe we're doing the agenda in order, so we'll have some issues around SAC, the Justice Project Needs Assessment, and then moving really into some, I'd call it court and judicial things. Wouldn't you, Stephen, kind of in that vein, some updates? And we want to thank the people that are here today to assist us with that. I see Jake Weebush, and I know there's others. I know Dave Reynolds is a member, but he's got some stuff today. So we appreciate all of you participating. And then at the end, we'll have the subcommittee updates. So with that introduction, am I at quorum now? Jill, I think we're close.
Yes, we have a quorum now.
Great. Okay, perfect. So Barry, it's all over to you for the Justice Project Needs Assessment update, and we do have a quorum present if you want to do some discussion.
All right, thanks, Jack. I'm trying to get my camera on. There it is. Good morning, everybody, and welcome to the Incarceration Prevention Reduction Task Force meeting. As you know, the Justice Project and the Stakeholder Advisory Committee has been operating now since January of this year. We kind of divided our work into three big buckets, and the first one that we tackled was hearing from Caleb and the other folks in the jail and our partners in EMS, talking about data, criminal justice data and data of emergency services responses, and we got a really good look at that. The next thing we took on was the behavioral health gap analysis, which was an incredible effort put forth by Perry Mowry, who's here with us today. That group really did an inventory of everything that we have going on with the county and behavioral health and throughout our community, and then kind of did a gap analysis and where we kind of need to go. The third bucket we worked on, which is we're deep into now, is the facilities discussion on what a new correctional facility would look like. Back in August, we had very broad agreement on a list that was provided by Lieutenant Erickson. He called it Caleb's wish list, and it was just a listing of the different types of functions and facilities that are needed within our jail. You know, behavioral health space, space for medical, dental, all the things that need to go into a correctional facility. Caleb did a pretty good exhaustive list that the Stakeholder Advisory Committee reviewed back, like I said, back in August, and there was a lot of agreement around that. So we proceeded on the assumption that those functions in the jail were important, and that we were going to look at how we could incorporate that into our plan. So our next meeting was actually last week, Thursday. So it's pretty fresh. The video is up on the website, the Stakeholder Advisory Committee website. So I'm not going to go over all the data that was presented because there was a lot. So it's very rich in content. So both the video and some of the presentation is available as well, that shows some of the results of the different polls we put out in the field. We did, and you all have gotten those polls as well. We've asked you to fill that out in our compilation of data. So that we're hoping to get that wrapped up today. Today was the closing date for those 3 polls, and those polls were on. Let's see, I wrote this down somewhere. I got so much stuff written down. Well, we talked about facilities and what's needed and location. That was one of the polls that we had. Needs and recommendations was another one, and then vision, values, and goals was another one. So the kind of the overall vision and goals of the project. That was aided a lot by the resolution that was put forward by the county council, which was planning principles for a new correctional facility that was done back in 2019. So we folded a lot of those goals that the council had and discussed those with the stakeholder advisory committee. So our last meeting, again, I said it was last week, we went over those polls. We talked about behavioral health out in the community. We talked about jail-based behavioral health. We talked about reentry services and other post-incarceration community support services. And we talked a little bit about housing as well, and the importance of that in getting folks readjusted after incarceration. So where we are right now is we have a couple of big events coming up. We have another survey that's going to be going through our partner VITA agency. That's another huge component of our work is community engagement. We're reaching out to both the tribes and the community at large, and we're looking to also include people that have been incarcerated and families of people who have been incarcerated as well, to be able to give that input. So we have a town hall coming up on November 15th, in which we will be discussing this with the community at large. So please mark that on your calendar if you can attend. It'll be both, it'll be a hybrid meeting, so it'll be attendable both by in person and through Zoom media such as this. So that's a big thing coming up. That poll that the VITA agency has created will be going out at the end of the week. That's going to be going out to a very large audience. So the community at large, and like I said, they're focusing on the tribes and other people of color in our county. So we're really following the GARE checklist and trying to make sure that we're including all the elements of that in this study. So I think, our next meeting is November, I believe, 17th. So a month from now. We're looking forward to getting a lot more information from VITA and on the public response to all the information that we're putting out. And that's going to take a little bit of time. We think that's going to go through the month of December and into January. So we think that we'll start assembling that all that community data that we're going to receive through the VITA agency, which will go into our final report. So I think that's it. I think that's all I have today. Any questions? Stephen and Jack, you guys are intimately involved in the planning of this, so please jump in if you have anything you want to add, because there's just a lot going on, and it's easy to miss some things. So with that, I'll take questions. And Jack, I see you turn your mic on.
It was more to call on people, but I was going to ask Stephen, do you want to add anything? I mean, the town hall thing's kind of a big deal. Like a lot of planning's going into that. Is there anything else you want to highlight, Stephen?
I would just underscore what Mary said, that the VITA agency's work with community engagement is targeting groups that we hope will feed into a racial equity involvement or look at the community's perspectives. So I just wanted to underscore that the SAC is adopting the same framework that we use in these kinds of questions. And lastly, it was sort of implicit in what Barry said, but you can see that our schedule, our time frame has slipped just a little bit because of the quantity of data, as Barry said, and because of the thoroughness of the process that we're trying to engage in. So the report we're shooting for when, Barry?
Well, either the last council meeting in January or the first council meeting in February. Just depends on how quickly VITA can get that information back to us and we can turn it around. We've also identified the need for an extra another additional stakeholder advisory committee meeting. And I know we talked about that at the meeting Thursday about doing that in early January. And some of our members said, well, why not do it in December? And I'm all for that as long as we can have meaningful data back from VITA by then. That would be the key in when we hold that meeting. So we're going to work with them and try to expedite this as much as possible. I would love to be able to get that report to the council at the end of January, but realistically, it may be 2 weeks later. So at least we're zeroed in on, like a 2-week kind of a window there. So we're really trying to keep this on track and get wrapped up as soon as we can.
The other thing I think I would just remind everyone is, particularly as the Incarceration Prevention Reduction Task Force acts as the statutory required law and justice council, we are striving to keep this group informed of what's happening, because we will be bringing, which varies discussed, information here with the hopes that when the report from the Stakeholder Advisory Committee goes to council, it's with the support of the Law Justice Council as well. And we're really kind of guardedly optimistic that once we all have a fair amount of information, that many of the processes, procedures, and actions will sort of make sense. And the hope is, by disseminating this information, that we get to a place where on many of these things we have strong agreement and support, which hopefully gets us to a better place than we are now. So that's the reason we're taking so much time with this. And I know for some of you, you're on both. And well, I won't say I apologize. It's sort of reinforcing, like doing math problems over and over again. But we want to, it's an important topic, and we want to make sure that people have the information. So, all right. Are there any questions for Barry, or I guess Stephen and I to a lesser degree on this topic? All right, Barry, the next topic is the Competency Restoration Workgroup.
Okay, so one of the things that we've revealed through all this work with the Stakeholder Advisory Committee and some of the work that the planning team has done, it's been very evident we have a huge problem in competency restoration, and that's a big problem in in jail space. So we have a lot of folks that are waiting restoration, and that process takes place down in Western State, and there's a huge backlog. I think right now the next available bed is May, is I believe what I heard last week. We had our second work group meeting on Friday. So that work group was formed to start looking at some creative solutions to how we might move that process along, or maybe do it locally. And so we put together a group. It's myself, it's Wendy from the jail. The prosecutor's office has invited the district court, superior court, public defender's office, health department. We all are just trying to be creative and think of ways that we might be able to increase our capacity for restoration. So we've reviewed a lot of data from an assessment that was done in 2017 and updated in 2022 of the current program that the state is running. These documents are going to be available for public view very soon. We also reviewed some of the data from Wendy on jail on wait times throughout the last few years with competency. We reviewed some documents that were sent out by the Legal Intervention and Network of Care, or LNIC. That's a program that was created in King County to do just what we're trying to do, to come up with solutions to this issue. And they're using what's called a prosecutor diversion program in their work. So we're going to be looking a little further into that. We have a person from Disability Rights Washington, which she is one of the lawyers that was involved in the True Blood case. She's offered her time next month to speak to the group about some solutions out there for funding and other programmatic ideas to take this problem on. So what we're trying to do is build a large statewide coalition and get, we want to get our legislators involved as well, because there's going to be some needs there through the state legislature. So we're just kind of trying to take this problem on, because we've seen what a huge deal it is. And by making a difference in this program, we can probably make a big difference in jail population. So it kind of fits into our mission. It's new. Like I said, we've only had 2 meetings, so we're just getting our feet on the ground, but it's pretty exciting that we are going to build this kind of a coalition that can hopefully, move the needle on this, because it is a big problem, and it's a big problem everywhere in the state. It's not unique to us here. So more on that as we progress.
All right, are there any questions for Barry on the competency work group? Okay. Barry, anything else you want to cover on either topics? I know it doesn't seem fair you can distill everything we've done into 10 minutes.
I know I gotta study up for the steering committee report now.
Yeah, you do. All right. Okay.
Thanks.
Thank you, Barry. All right, Stephen, I'm sorry, I'm Stephen. I'm going to turn it over to you, and I think we are at the pretrial processes work group and Jake Webush.
We are. Thank you, Jack. Barry, I'm going to just give you a heads up. Because of the centrality of the competency restoration work you've initiated, I'm going to suggest that we make you a regular reporter in our meetings, the way we do with some of the subcommittees as well. So stand by next month.
Sure, that sounds good, Stephen.
Okay. So the next item on the agenda is the pretrial processes work group headed by retired Superior Court Judge Deborah Garrett and sitting Superior Court Judge David Freeman has been active the last couple months, continuing to work through the implementation of the public safety assessment, the PSA, the pretrial risk assessment from Arnold Ventures that the Superior Court judicial officers have adopted, as well as other pretrial issues, including the Superior Court Pretrial Services Unit and progress and issues going on in district court probation, handling district court pretrial matters, and by contract with municipal courts. So we wanted to keep the task force informed on this. Jill, I didn't see when I looked 30 seconds ago that Judge Garrett had joined the meeting. So I think, John, you might be on for an update from the work group itself. And then Jake, thank you for being here to catch us up on how things are working in district court. John Kraus, are you available to report on the work group and where our discussions stand and where your pretrial services office is?
Yes, so I'll kind of give you a last updated report on our last pretrial service work group meeting earlier this month. We've been having them probably bi-monthly, every other month, the way it looks. Our next one is in December. In our latest meeting, maybe just to give you a summary of what was discussed and how we're moving forward on some areas. Right now, we're starting to look at alternatives to incarceration, or in lieu of incarceration, as the EHM or GPS type of monitoring for Superior Court. We're not actively doing it, but we're looking into it, and we're seeing what other jurisdictions do in their policies with some of their pretrial services and Superior Courts around the state. And we'll be contacting our risk management pool and getting their input on the liabilities and those kind of things and the costs. And we're looking at what types of policies, who would be appropriate to be put on pretrial services, considering the public safety end of things. And that's probably as far as we've got, we're going to have a fuller report coming in December on those different researchers. There are vendors in the wings that we can engage with if we do move forward. That seems like it is fairly affordable for us, but there'd have to be new policies developed, and who would be required to be put on them, or options, or violent or nonviolent, and victim concerns. All those will be brought into consideration once it's implemented. And then, so that's with EHM. That was in our last meeting. And then another update, we're still ongoing with the public safety assessment. We have been using it probably for, gosh, I want to say about 2 years. It was suspended for a while during COVID, but it's been re-engaged for over a year now, a year and a half. And that's just simply the public safety assessment. It's a 12 static questions. It's basically 12 questions asking about a defendant's background. They're mainly their criminal history and failure to appears. And it gives a one-page summary, and it's presented to the judicial officers along with public defenders and prosecutor's office at the first appearance. And it just gives a ballpark figure on the safety risks this person would hold. And they help in the determining release plans if they haven't booked and released or anything else. It's usually only used to set conditions of release at the first appearance. And through that, we're going to be obtaining more specific information and research with our statistician down in Olympia, Dr. Peterson. He's going to help collect through the PSA, public safety assessment, different areas that might be of concern in our local jurisdiction to help refine, and it'll basically help the judicial officers make determinations on the bench about release. And gosh, probably later in the summer, there was sent out a survey on about 24 to 26 survey questions on what was most important that were sent out to our pretrial process work group on what would be important, what information to collect and to start researching and to gather up from the different databases that we use. And so Dr. Peters is compiling them. And a lot of those questions were coming out of a pilot site down in Pierce County that the Arnold Ventures and Foundation are helping with. They're implementing the PSA along with the 2 to 3 year research program. So a lot of our questions came from them, and some of our background and different things that they're doing there will help implement here. So that's pretty significant work site. They have their consultants working along with pretrial services and the county down in Tacoma and Pierce County. And we're also working on a violent crimes list for the PSA and what's considered violent crimes in our jurisdiction. So the prosecutor's office and Maya and her office, the public defenders, they're working on this along with the judicial officers on what would be considered violent crimes, and it would go in and have a flag attached to it and raise up a risk level. And so they're completing that, and some of the other violent crimes lists that are used around the state they're looking at too, so there's more of a consistency in the superior courts. So that's part of the meeting we gathered our information on. And I guess coming down to our unit, we've been supervising since 2019. I guess we released August of 2019. We started supervising defendants out of pretrial services, and the PSA was engaged in February 2020, was lifted for a year because of COVID, re-engaged in April 2021. And so we do have some information stored on it, but we don't have any substantial that would help make decisions on where we go from here. But that's what we're coming down to, is specifically finding what exactly we want to find and capture that. We're going to have an upgraded system with pretrial services, our private vendor, later this year, which we can tailor make it for our jurisdiction, what we really want to have collected, and provide that information. Along with down in Olympia, our statistician will help work with us on that. Currently, we got 100 on pretrial services, and about up to 50% have either absconded or still incarcerated, but they've been assigned. If they release, they'll be assigned to us. and reporting into us. The others have absconded. That's since 2019, since they've been assigned. And maybe just, I don't know if you're familiar with the public safety assessment, the 12 questions, but you can either go online and it's used by hundreds of jurisdictions across the country. And some even have like in New Jersey, the police in their patrol cars actually run a PSA, and it's automated into the state system to see what kind of risk, if they should cite them on right there in the field or have them arrested, and provided that information, the booking. So it's extensive, and there's many uses you can have with it. So it is a really good tool. And I say it's a good, each one takes 10 to 15 minutes to complete. We do a local, statewide. Basically, it's all based on criminal history and failure to appears. And it rates them. Right now, we have a 3-tier program. It's low, medium, or high risk. Low is somebody with very low or no criminal history. And sometimes it takes in the age. And most definitely if it's domestic violence, sex offense, and if it's on the list of violent offenses, it automatically bumps it up to a higher level of risk. Even with a low criminal history, it still might bump it up depending on what the charges are. And so, and then there's reporting procedures for each level to come in and check with us. Currently, we aren't running drug testing through it. We can, and we just, all these things need to be ordered by judicial officer. And we are also wanting to work closer with the LEAD program. It's a referral service, either directly in the field, the police can refer, or once they're booked into pretrial services, we can refer them out to a LEAD program or other opportunities for interventions. You know, it's all voluntary at this point because it's pretrial. But so that's just kind of a background on what we're doing. Did that help any?
Yeah, thank you very much, John. That was really a thorough overview of the work group and your office. Thanks for your efforts. The one thing I would say is it should be obvious from John's report that we're digging into a lot of the details of the PSA and how it would work in the process from booking to pretrial release. One of the things that's always been sort of assumed, I think, in task force discussions and even in the work group discussions is that electronic home monitoring of one sort or another will be a piece of the monitoring process for people who are released. That's been a very effective tool in the municipal courts and the district court. In Superior Court, you're starting to get more serious charges. And so the question, quite rightly, has been raised, is that an effective and evidence-based tool for returning to court, avoiding failures to appear, or accurately assessing the risk of new crimes if released? And that's a question that's really just come up fairly recently, but we are taking seriously in the work group. And Dr. Peterson from the Administrative Office of the Courts has also undertaken a little bit of digging into the literature around electronic home monitoring for more serious charges. And we're waiting results of what he finds out for that. So all of that is for the purpose of looking for tools that John's office can use to monitor not just the low risk people, which are pretty obvious candidates for release, but the medium and the high risk people, because there are a significant number of those as well. And if we can find an effective way not to hold them in jail, but to continue to hold on to them in terms of contact for the continuation of their case, we'd like to do that, and we'll be able to reduce the jail population for those groups as well. So before we move on, there are obviously a couple of questions already in the queue, and I'll welcome any others for John. I see Raylene and Heather so far with their hands raised. Raylene?
Thank you, Stephen. Thank you, John, for your presentation. I was just curious if you had any statistics on individuals that have been on this program, that have been released, and if they've committed any new offenses, whether misdemeanor or felonies, while they were on release.
Yes, we do have a running list of that. Just a ballpark where we turn that in quarterly to Dr. Peterson, our statistician. I'd say there's probably close to 38 to 45% recidivism rate, which means a new law violation has occurred within the scope of they're on pretrial. And we're just gathering the ones that are sent to us, not overall numbers. Many haven't been sent to pretrial, which have that data we're not collecting for if they've broken new laws or not. So does that answer you?
Yes, and then basically your monitoring right now is call in, check in, are people coming in person as well, or?
Both, yes.
Okay.
And basically lows are initially they got to come check in. We get their information and they get text reminders of their next court dates. And then high usually are weekly reporting in person or some sort of electronic.
Okay, thank you.
And let me just follow up on what John said from the work group. The measuring stick for the work group is not just new crimes. So when John says a certain percentage have recidivated, I'm not sure who that encompasses. John, maybe you can clarify that. But the work group is targeting new violent crimes, new crimes of violence, which is part of why we're spending so much time carefully coming to consensus about what that list of violent crimes will consist of. That's really the public safety estimate, because knowing how many people have behavioral health or substance use disorder issues, if they're released and if they still have an active substance use problem, they are going to recidivate in a relatively low level, but maybe not a violent level. So that's the kind of thing we're trying to capture in the decision to release. Heather.
Good morning. Thank you so much for the report, John. I was just Googling around to see additional reports in Whatcom County, and it's good to read into it. I wanted to say a couple of things. One is I know that there have been concerns about the potential disparate impacts on different races. And I'm wondering if I believe those have been addressed through the adoption of this tool. But I am also wondering if you're tracking data in any way to ensure that we're not seeing any disproportionalities based on the use of this tool. And the second question I have is, I'm curious about the practice of what kinds of supports. I know that the pretrial, it seems to me like the pretrial office is really focused on compliance with the court. Some people call that pre-carceration too. I'm wondering about if there's opportunity, or if you're already more from like the social worker mindset of, are there supports that we can offer that would actually help rehabilitate and put somebody on a different track? And if that's part of the pretrial services management philosophy at all.
Yes. So to answer your second question first is yes, there's a balance between compliance and I guess rehabilitation, depending on the risk level, their crime, what their background is, and their level that come out on the public safety assessment, and along with common sense. And it's also noted that it's all voluntary if they want to have a recommendation to drug, alcohol, mental health, the local work source, job, housing, and we also have a referral built up. We can send people to the LEAD program. Are you familiar with LEAD at all? Yeah, and that's really great. That's a really powerful tool, but it's all recommended, and because they're pretrial and they're not ordered yet. So there's a fine balance between that, but we just want to make sure that they get. Our primary goal for most pretrials is get to your court hearings. You don't miss those, along with let's try not to recidivate or break the law or abscond. And that might need some rehabilitation or just compliance, depending on case by case. Does that help? And then the first question, can you clarify that again?
So there's a long history with this question. Stephen Gockley has convened meetings in our community to talk about this. The ACLU made this a big issue a few years ago when we just started talking about pretrial risk assessments and the potential for, because of using the I think there were concerns about an algorithm for sure. And then there were also concerns about using criminal history as a factor in the decisions about pretrial support services, what have you. So, and there, particularly the concerns were around if this could, if we would see different outcomes based on racial identities. And so with our community's focus on racial equity, with those concerns having been brought up, I actually am not really clear on how those got resolved through the process. I believe they were, and I probably missed a meeting where that was explained. But my question for you is, are you tracking that at all? Are you tracking race in your office? And I want to offer too that our community is here to support you in that, to make sure that that tool is not disproportionately affecting any people of color.
Yeah, what that'll do is what we do, the tool itself is objective. And so the information we get is we come out of the community, maybe out of policing patterns or specific areas of a city or something. But the tool itself is very objective. But through that, we are going to start collecting the demographics of, race, background, those kind of things. And so that hasn't been compiled yet, as we're working with Olympia, our statistician, and how we can fit all those and take a look at if there is, and that it will definitely be something that we're going to have to look at and collect and focus on and try to alter, refine.
Heather, there are a lot of layers to the onion of your question, and I'll try to speak to them a little bit also. Over the last couple of years, well, let me start one step back. There has been a national discussion about embedded potential for racial inequities in the criminal legal system, and therefore in any risk assessment tool that relies on criminal history to make a decision. That's unavoidable in some ways because criminal history is the strongest predictor of failure to appear or commission of a new crime if released. So far over the last couple of years, the general opinion on the best practice is to use a risk assessment tool, a standardized tool, because it means all the judicial officers have a uniform basis for making consistent judgments rather than subjective judgments, first of all, and varying subjective judgments from judicial officer to judicial officer. If there's a close eye put on how that's actually carried out and what the data shows in the use of the instrument. That's been the approach here in Whatcom County. The Pretrial Processors Workgroup did a long and careful review of many of the risk assessment tools used across the country. The PSA stands out as the most likely to both flag and limit the continuation of racial inequities in the criminal legal system. We've tested it before we adopted it with Whatcom County cases in the past. We are set up to validate it periodically as we go forward to make sure that it's not enhancing and in fact, ideally is reducing the racial inequities that the Vera Institute report found. John mentioned the 24 to 26 questions that we're compiling for Dr. Peterson because we're building our data around that, and core questions in there have to do with racial identity and the equities that we might be finding and using that. So, and we've also engaged a couple of people of color in the community to sit down with us when we do those validation reviews. So I think we're following best practice there in terms of paying really close attention, giving very high priority to minimizing any infection of the use of the risk assessment tool in pretrial releases. It will of necessity, because it is a standardized instrument. It will use criminal history, but we're trying to factor out the kinds of inequities that could creep in if one were doing that without paying any attention to these questions. I hope that adds some to the background and informs the task force as well. Caleb, you're next.
Good morning, everyone. I just wanted to ask a question about, Stephen, you mentioned recidivism as it pertains to new violent crimes. And I was wondering, is that the statutory violence delineation, or is there more of a broad spectrum approach to things that might be a community safety issue in terms of maybe domestic violence or other public safety crimes? The reason I'm asking is because in general, we aren't booking in our community anyway, anybody who isn't representing some form of a safety risk for the most part. So they wouldn't necessarily be incarcerated again unless there was some other underlying issue. And I just wondered, is there a line there that is strictly delineated, or is it a bit more fuzzy than that?
Well, I asked John to chime in support if he wants, but that's sort of the focus of the conversation John alluded to. We're basically at the core using the statutory list of violent crimes. There's some a little bit of debate around the edges of that. There are a couple of charges that could be or could not be included. And lastly, I will say that Carol Donovan, a longtime victim advocate with a focus on domestic violence issues in the municipal courts, has raised the particular concerns around release of domestic violence charged individuals, because that's sort of a special case. And again, part of why this is trudging along, I think all of us feel like, is because of the booking restrictions that are in place and the slow re-engagement of trial setting processes, especially in Superior Court, a little less so in district and municipal courts. So there are a mix of factors that go into the situation you're putting your finger on, Caleb. But largely we're I think at present working from the same list of violent crimes that you would be in booking. John, do you want to add anything to that?
No, I think that's pretty accurate. There are things on the fringe that we're working on, but I think the core of it is pretty solid.
Darlene, sorry, I was muted.
That's okay. Hi there, I'm Darlene Peterson. I just wanted to point out that the revised Code of Washington has some standards. And one of the things those standards states is that there are certain offenses that do not qualify for electric home detention. So as you're looking towards seeing felons be able to do home detention, the RCW is 9.94A734. And there's a list of those offenses that cannot be approved for home detention. So if this is something that seriously courts would like to consider, I think that it's going to take some legislative review. And so I just wanted to put that out there.
I think between Judge Garrett and Judge Freeman, we're aware of that, at least in practice in Superior Court. Darlene, are you saying that there's interest in reducing the prohibition against electronic home monitoring or expanding it? Where would the legislature weigh in on that?
I was looking at one of the offenses says any drug offense. You can imagine how many offenders that would keep off of home detention. And with the recent changes in legislation, it makes me wonder if, this was passed a long time ago. It makes me wonder if this is something that might be subject to review based on new rulings that we've had, and might expand, allowing offenders who maybe would not qualify as a violent community safety risk. And so that was my point.
That's valuable information, and John and I'll make sure that gets put on the agenda for the work group. Raylene.
Thank you. Just to comment on Darlene, with legislative changes, as long as there's going to be jail restrictions on the ability to have people incarcerated, sometimes having home detention as some type of accountability for somebody's actions rather than waiting lengths of time is beneficial. But when legislative rules say we can't do that, I think that's also something we might want to look into because of that, unless we can use some of the jail for some of these other offenses. Thanks.
Thank you, Raylene. Jack, you have your hand up.
I do. Thanks, Stephen. On the EHM, I want to echo that I think we definitely need a review. I think my role here is, I can't remember if I'm a person who was in the system or family member, but I think recently Jake knows this, but with my own son, he barely got on EHM. And when this was conceived, some of these restrictions, things like scram bracelets to determine alcohol, the ability to do drug testing, the ability to make the electronic home monitoring more effective for people, particularly with substance use disorder, didn't exist. So I think considering that, as well as I think there are some offenses that are charged that to me seem in the middle ground. There are some that obviously someone should not be on EHM because it's not appropriate for public safety, but there may be others where it is. So I think in a perfect world, to me, there would be more autonomy on a local level to determine some of those calls about whether something is legitimate or not. It puts a lot of burden on the sheriff's office, for example, to try to make a determination if someone is eligible. So I think definitely, if we're advocating for EHM, having perhaps a different process of determining what crimes. I mean, the drug one's obvious. You're going to say no drug offenses are eligible. Well, you're in trouble. So those are just a few thoughts. And from personal experience, we battled a little bit and we're successful. The sheriff's office agreed it was appropriate and it worked out well. But not everyone probably has that experience. So thanks.
Thank you, Jack, both for the general policy comment and sharing that experience. Any other questions for John on Superior Court, public safety assessment, or the pretrial services unit and its monitoring capabilities right now? I'm not seeing any. So I'd like to shift over and thank Jake Webush from District Court Probation for joining us this morning. Jake, you're on the agenda to talk about District Court pretrial services, use of electronic home monitoring, if you will,
Sure.
and any other relevant topics to pretrial.
All right, thank you. Thank you. Well, yeah. So here at District Court Probation, just a quick snapshot, we service about on an average 2,000 clients, and about 250 to 300 is probably the range of those that are pretrial supervision. We provide pretrial and post-conviction supervision to obviously here at District Court, as well as Bellingham Municipal, Blaine, Everson, Linden, and Sumas. We have contracts with those cities to provide the services. We do have a specific pretrial unit, but we also have a behavioral health unit, as well as a high-risk DV unit. And the reason I mentioned those is depending on the severity of a case or the needs of a client, they could be referred to one of those units over the pretrial monitoring unit, but receive the similar services, obviously, just with a little bit different assistance there. We provide the pretrial referral comes to us with the conditions set from the court. We generally are not involved in the process until after the conditions are set and they show up in front of us. We monitor all those conditions and do not alter those without judicial authority to do so or approval. Common pretrial conditions that we monitor are good behavior. So through record checks, maintaining clean and sober, through monitoring the VUAs and breath tests, verify ignition interlock installations for DUI cases, obviously, and assist with license plate surrenders, as well as weapon surrenders for DV cases. And then the installation and compliance monitoring with the electronic equipment program, which are generally transdermal alcohol like SCRAM, TAD, or the portable breath test devices such as SoberLink. We work with our clients in a variety of ways for reporting that include in-person, Zoom options, telephonic, as well as when we're in the remote courts, we do our best to meet with our clients there because it's usually a little easier access for them specifically. We have a UA tech that assists us multiple times a week, as well as the probation officers conduct those tests as well. We average probably, say, 120, 130 tests per week amongst all of our active clients for monitoring. As far as the electronic equipment that I mentioned before, for the district court clients, we work in partnership with Whatcom County Jail Alternatives Program there at the jail. And we currently have about 34 individuals actively monitored right now. The program has served, I think, since about 2018, just under 300 individual clients, so I have 296 to date. And it's a 50-50, almost exactly split between pretrial clients and then post-conviction clients that we utilize that program for that are struggling with sobriety. We have very tight systems in place for our communication with departments between us and jail alternatives to make sure the installations and all the violations are addressed in a timely fashion. And then for the municipal courts, we also provide very similar services and provide the same procedures and tight timelines for the programs as well, but they utilize friendship diversion services. And some of those services, the municipal courts do also have some active GPS monitoring for DV cases, a smaller percentage. We also provide text messaging for all of our appointments, including substance tests, as well as for most court hearings here in Whatcom County, including Superior Court, just text reminders that we're doing. So I think that's kind of our services in a nutshell. Questions out there for us?
Jake, before I take questions, you gave a pretty interesting presentation at the last pretrial processes work group meeting about some therapeutic approaches that you folks also engage in with, I think, including pretrial people. Would you sort of summarize some of those for us?
Sure. So again, these are primarily though for post-conviction because we can't impose, the court can't impose treatment. It can be agreed upon by parties, and we can work with them that way. But yeah, so we have the DV POTS, which is the Domestic Violence Perpetrator Opportunity for Treatment. It's a mouthful to say, but there's money there for reimbursement of services for district court and Bellingham Municipal Court DV evaluations and treatment. We have in-house DV MRT, so it's a moral recognition therapy specific for DV clients that we also offer and provide those services for all courts. And we utilize that when funding is tricky or they're in conjunction with other programs or prior program hasn't worked, so we'll try this one. We now have just a general moral recognition therapy, a 12-week group for people that are struggling with making great choices to maintain a non-criminal lifestyle. So we're working on those clients, and we usually utilize those when they've had violations. We're trying something new and trying to provide them with a new resource. And we also just started recently a anger management component as well here. So a group that's offered once a week. All of those are of no cost to our clients. We provide the workbooks and the probation officers do the facilitation for those. So again, those are primarily more post-conviction related, but hope that answers your question, Stephen.
It does. Thank you. Any questions for Jake and district court probation practices? Okay.
Thank you.
Thank you very much, Jake. Appreciate your time. Moving on in the agenda, the steering committee wanted to update task force members on the status of the restarting of court proceedings. Excuse me. The restarting of court proceedings in various jurisdictions. Got a frog in my throat, sorry. We're pleased to have representatives from the various court systems in the county to update us on caseloads, processes, progress in coming out of the COVID period. And I think I saw earlier, Dave Reynolds was on the call. Dave, if you want to come on and catch us up on where Superior Court case progress stands, we'll start with you.
Well, we're open for business. We've been over the last year, we've had jury trials available. There's only been 34 jury trials, however, during that period. Actually, sorry, it's been at 34 weeks, we've only had 13 jury trials. And since then, we've only had 2. We have courtrooms available for jury trial. People aren't taking advantage of that for some reason. I think there's some things that play into that. People on warrant status, people who are committing new offenses and racking up additional charges are impacting that backlog as well on cases. We are able to now operate jury trials using 1 courtroom at a time, or using each courtroom available. Before we had to take 2 courtrooms to have jury trials because of social distancing. We're not having those issues anymore. So the availability is there. However, I think there's a lack of motivation on defendants to resolve their cases, and in other circumstances, disappear, which doesn't help the situation at all.
Thank you, Dave. Any sense of prognosis for the next 6 months or so with expanding trial setting, case processing expectations?
Well, I think that, the availability is there. The judges have taken a hardline stance on continuances. They're not going to look at continuance and the merits of that. And in the past, just because of, well, for a variety of reasons, it was very easy to get a continuance on something. Now, cases now that are 2 years old, they're not going to, allow a continuance on those cases. And they're not going to allow any just agreed continuances on things. They're really going to hold people's feet to the fire on getting these cases resolved.
Thank you. And Eric, thank you for raising your hand. I'm sure you have a lot to add to this conversation. Go ahead.
So I just want to ask Dave a question. If you can tell us about resolutions, if they've been increased recently with the judge's new procedure, and just so that everybody understands what Dave was saying, so you understand completely, is that for the last several years or couple years with COVID, cases have been continued without judicial involvement. And now the judges are stepping in when cases are 2 years old. And I know that the courts considered doing it, stepping in when cases are only maybe a year old or a year and a half old. These are things that were talked about. But based on our backlog that we currently have, 2 years sounded like a reasonable place to start. And I think that's appropriate. That's the right thing to do. I'm hoping that as things move along, the courts will get involved and question continuances when they're only a year or a year and a half old, or maybe even earlier, which would be really nice too. But Dave, with that new rule, can you tell us if there have been more resolutions?
Well, the rule's still fairly new, but there has been some cases moving along that otherwise may not have.
Good, and that's been my impression. I've been hearing about how that's happening with some of our cases, but I just was hoping we'd get some stats at some point. Resolutions are important. That's going to reduce our backlog, of course. And we are starting to have more trials. We had 2 last week, and 1 continuing through today, this week, which is good. And yeah, I think there's been an uptick since the courts put this rule in place.
And hopefully that will continue to make an impact.
I'll just add, unless Maya wants to, that in discussions about case processing, she's provided the important background information that all of us should be aware of as well, is that we can say the courts are available, but that doesn't mean that the counsel and the parties are ready tomorrow to jump into a trial. That means you start developing the case at that point when it's been on hold for COVID reasons, largely for a long time. So there's a lead process to prepare for trial on both prosecution and defense side. And so I think that process is well underway in a lot of cases. So hopefully as that work gets done, the pace of trials, the imposition of resolutions will start to clear up a little bit of the backlog that accumulated.
And Stephen, one of the other factors that we've seen in this over the last 2 years is the large number of conflicts the public defender's office is having with cases as we get more and more of them, and the hard time finding attorneys to take these conflict cases. I've had to reach out as far as Tacoma to find an attorney in the past to assist us. And we're constantly, everybody's at caseload standards, or, just as more time goes on, more conflicts develop, and that really slows things down. In addition, when I'm having to get out of county attorneys, they don't have the relationship with our prosecutor's office that local counsel does. So it makes it harder for them to resolve cases as well. So that's, another variable that's really impacting us. Our assigned counsel budget's twice what it was 2 years ago. And we have twice as many cases on there, much more serious cases that we're having to take on and try to resolve as well. So, that's really a factor that does play into this quite a bit.
Thank you, Dave. That's really valuable information that I wasn't aware of, but makes complete sense. Eric, go.
Yeah, sorry, I want to throw something else in just to let y'all know. We're starting a new process here with our Superior Court cases. We're looking at some of our lower level things and direct filing them into district court where things are able to move a little more quickly and easily. We've had it going for the last 2 weeks, and we're figuring that we can move about 5 cases a week, 5 new cases a week into district court, and that adds up. That adds up to a lot of cases. It's a couple positions essentially in the public defender's office based on their caseload limits. But anyway, that's our plan going forward. We think it makes sense. We're giving people 6 months to resolve them in any which way in district court. In other words, if they want to go to trial, great. If they want to plead out, great. And if they don't do anything, then we're going to refile them after 6 months passes in Superior Court. So we're giving them some incentive to get things done.
Thank you, Eric. That seems like an important step, and appreciate that. That would be a perfect segue on the agenda to go to Bruce to update us on district court, except I don't see Bruce on the screen. So, Raylene.
Thank you. I think Jake and I were supposed to help out for Bruce this morning. Bruce had given us the information from our legal and justice meeting in reference to the status of jury trials in district court, if that's what you're referring to. The jury coordination is provided for multiple jurisdictions. So they have a jury coordinator that provides information to the municipalities in Whatcom County, as well as district and Superior Court. They often have very little lead time for putting together a jury, which means their team has to be ready at all times. And during the pandemic, this service took more staff and resources because trials were canceled with little or no notice, as they had to put extra precautions in place for those trials. Jury summons mailings have increased from 600 pre-pandemic to 800 currently per week. So far, district court has run about 12 trials and Superior Court has run about 13. They currently have enough resources to run more trials. They did not see the big influx of jury trials that they were expecting. District court at this time does not have any backlogs. I'll let Darlene speak on Bellingham for that and for their trials. And then for the small cities, we have seen an uptick in trials. Currently, Sumas has a trial this week. Blaine and Everson just finished a trial. I have a couple other trials set in Blaine. So that's outside of district court, but we are seeing trials going more frequently than before. And when I say it that way, I mean that most cases resolve without going to trial. But we are seeing an uptick in people wanting to take their cases to trial, and I'm not quite sure if that's the same with me, district and superior court, but we are seeing more trials.
Thank you very much, Raylene, for filling in for Bruce. And Jake, do you have anything you want to add there from the district court perspective?
No, I think Raylene summed it up very well from similar presentation last week. So thank you.
Okay, thank you. And Raylene, either now or in a couple moments after Darlene, I'd appreciate it if you'd introduce Ronnie and fit her into this conversation. I don't know if you want to do that now or not.
Thank you. Darlene, would you like to go first, or do you want me to start?
Well, why don't I just do my trial information? I was just going to let you know that in Bellingham Municipal, we have 24 jury trials backlogged, but some of them are newer. We have 2 from 2019, 9 from 2020, 7 from 2021, and then 6 from 2022. Both of the 219 trials, one is set for this week and another one in a couple weeks. So for us, it doesn't seem like jury trials have been the issue, which seems to be all the way around. We've been doing them for a couple months. Many times they're resolving and not going to trial. Our biggest issue with case processing is the amount of warrants we're getting. Because people go to jail and are not being kept there, they're missing their initial hearings. And what happens is then they're not reporting to court when they're giving us an assigned time. During COVID, the Supreme Court had put a hold on serving warrants unless it was a severe community safety issue. That was lifted, and at the time before we started working on those warrants, we had 680 held warrants. Those were warrants that were ordered by a court but held until they could be issued. And we've dropped that down to 466. So we are working through that backlog, but that's still quite a few warrants that are out there hanging with people. The biggest problem is that when people are not coming to their arraignments, they're garnishing new warrants. And so warrants are increasing. We've seen over 1,000 number increase in our warrants from last year to this year. And what that's doing is, rather than resolving cases, defendants just keep stacking more and more warrants. It does affect our jury trials because many of these jury trials are the same offenders who keep getting new charges. And so that's part of the problem, is when we're not able to book into jail. We're seeing that grow. I know that Jackie Mitchell of the health department mentioned they not having that initial hearing are not able to catch many of the mentally ill that they're able to catch during the first appearance. And so I would think that is the biggest detriment that I'm seeing in our court to date, with both what happened during COVID and then now the restrictions in booking. It seems like not booking lower level offenders makes sense, but in a sense, those defendants are also paying for not being able to have those first appearances.
Thank you, Darlene. That's very informative. Probably something we'll need to discuss in one of the forums, one of the subcommittees. Okay, Raylene, I think we'll go back to you for further update on small cities and introducing Ronnie from Friendship Diversion Services.
Thank you. I also wanted to briefly mention something that was mentioned at the Legal and Justice Subcommittee, was the implementation of a family court through district court with Angela Anderson. I think it was briefly talked about a little bit with the DV, MRT and POTS program. But it seems like it's also being an option for those felony charges that can be reduced down to district court to have a robust treatment plan that's being offered for those that are eligible for that through the district court family program. So I just wanted to make sure that was thrown in there. And in reference to all the other small cities, we are also seeing an uptick in warrants. Defendants know that they're not getting booked on misdemeanor crimes. And with that knowledge, they're not coming to court. Even when they're booked on felonies, a lot of times the turnaround time is so quick that the warrants stay active and we don't ever see them until they're booked on a more serious charge. So we're hoping to make some changes on that. And now I'm going to introduce Executive Director from Friendship Diversion Services, but I would like to see if Jill can put up some slides for me that Ronnie provided us with some statistics from the small cities. So the first is showing referrals, enrollments, and completions from Blaine, Everson, Sumas, Linden, and Ferndale. Ferndale is pretty much just doing post-conviction home monitoring. I know that they've done a few pretrial services, but they recently just started with the program, so they haven't done a whole lot yet. Linden added them last year, and after speaking with the clerks in Linden, they both said that they're very happy with the services that are being provided and are using it a lot more than they expected to for pre and post conviction matters. Blaine, Everson, and Sumas have been using it, I believe, since 2000, at the end of 2017, the beginning of 2018. I'll let Darlene speak to what they've been using. Can I go to the next slide? This shows another graph of the enrollments and completions for the small cities. I'm not going to spend a lot of time on this. Next slide, please. And so this is just statistics. I can have Jill send them out to those that would like them, or everybody, and you can read them at your leisure. But it shows that those that are on Scram, how many sober days that they've been, and the percentage is pretty astonishing. For 99.7% of days sobered while they were on Scram. Scram detects alcohol through their skin, and so this is something that Ronnie can answer more questions about, but this is used for pre-trial as well as post-conviction. So individuals that have been charged with a DUI can be put on this. Typically, our judge will end up putting this on individuals that have had at least one prior DUI, so that they're released from being in custody for a longer period of time if they're a high risk offender, and that being something that was discussed before. They're looking to see if individuals have had offenses in the past that are similar to this, if they have a history of not appearing to court, what the level of the blood alcohol was, how serious the offense was, if there was accidents involved, if there were children in the car at the time of the DUI. These are all factors that the judges are going to use to consider whether they want to put them on some type of pre-level monitoring, and Scram is one of those systems. Sometimes they're just put on Scram, sometimes they put them on Scram and pretrial monitoring with the Whatcom County Probation and Pretrial Processes Group. And we also do the home detention, and the home detention incorporates GPS as well. You can remove this slides now. Thanks, Jeff. The home detention has GPS location monitoring, and this is used so that we can determine if people that have no contact orders, either pre or post sentencing, to keep them away from the victims. It will alert the law enforcement if it's a pretrial matter and they get within the 500 feet or 1,000 feet as notated by the order by the judge, that they are getting close to the victim's residence, school, or daycare, whatever inclusions are put in there. That's what Friendship Diversion Services will monitor. And then if it's a post-conviction and somebody is sentenced to do jail time, then for the practices for Everson, Sumas, and Blaine, Judge Bobby usually says you can't drink while you're in jail, so you're not going to drink while you're on home detention. So he will establish them to be put on FDS, SCRAM, and GPS monitoring while they're serving their sentence. That is not always the case with every court or with every system, but that is typically what they do in Blaine. But I'm going to let Ronnie maybe touch on any fine points that I missed and any questions that you may have for her, because she is way more versed on friendship diversion services and how the product works.
Ronnie, thank you for joining us, and we'll turn the floor over to you, and probably you'll have some questions at the end.
Great. Well, thank you for having me, and good morning, everybody. I did just want to follow up on Raylene's comment about sober days. Sober days, for those that are serving on SCRAM monitoring equipment, is considered a 24-hour period in which there was no tampering with the device and no confirmed drinking events. So the statistics for the cities, those sober days are pretty high. And that means that, you know, during those time frames for those monitored individuals, they were not only not drinking, they were not drinking and driving, they were not having alcohol-fueled domestic violence incidents. And the city's statistics over the years, as I've watched them, their completion rate for people being successfully monitored, both pretrial and post-conviction, is pretty high. Their success rate, even for EHM, is in the high 90s. You know, for monitoring both pretrial and for those that get to serve their sentence on electronic monitoring. The only other thing that I have to add that I'm fairly excited about is I've heard off and on a few people mention the active monitoring for domestic violence situations. We have just wrapped up what we call a demo, where we have taken equipment and put it to the test on a victim notification system. So our GPS device is called a Rely Alert, and with that GPS being on an offender, we now or very shortly will be able to implement an employment notification for victims. So a victim has that cell phone becomes like a mobile traveling exclusion zone for the offender, so that the victim is notified if the offender is within a proximity location. And because those that are on domestic violence active monitoring, they have static zones, the home, perhaps the work, the school, those zones that stay as an exclusion zone for the perpetrator, but it doesn't protect the victim when they're out in the community, grocery shopping, a laundromat, you know, doing things that they normally do. So this program will, in essence, just create kind of a zone around the victim if they're carrying their cell phone with them. And that's really all I have. And that was just to let people know that that is him in the small cities, but I just wanted to let people know that.
Thank you, Ronnie. You were breaking up a little bit there, internet connectivity, I think, but I think we got everything you were trying to report. So one question I have is, one of the questions around EHM of late in domestic violence situations, especially, is that when a GPS restriction registers as being violated, that's a report that goes into law enforcement, but there isn't 24/7 reporting, as I understand it. So law enforcement might not get that report until later. And so there's some concern about the actual protection involved. So if I understand that correctly, your pilot shows some promise for a little broader time period of protection. Do I have that right, or can you
If-
correct me if I don't?
If the court orders what is called active supervision, and if there is a victim with a protected party's address, then there is 24-hour monitoring. The GPS device is real time, and it is pinging the device for those people every minute. And then my staff is actually on call to take any calls that come in regarding violations, which include not just proximity violations, somebody's getting close to their exclusion zone, but also if there's tampers to the device, if
Ronnie?
what's going on.
We lost you there at if there are tampers.
Stephen, well, hopefully she can unfreeze herself.
Yeah.
If somebody tries to cut off their device and they're on active monitoring, or if they're in violation of a no contact order, then 911 will be dispatched and notify the victim.
Great.
So there is active monitoring when it is ordered by the court.
Great. Thank you, Raylene. Okay, I think Ronnie is going to stay frozen for the moment. Raylene, anything else you want to add from Lane and small space perspective?
Maybe touch up from Darlene and their use of home monitoring, and then if Ronnie comes back on and there's any other questions we can ask.
Okay, and as you can see with the pretrial processes discussion and the court proceedings discussion, the electronic home monitoring issues, which we gave a separate agenda status to, really bleed into all of those, and we've been discussing them. So Darlene, do you want to talk about EHM from the Bellingham Municipal Court perspective?
Sure, Stephen, thank you. We've been using electrical monitoring since 2016 now, and it is just a robust program. We are keeping hundreds of people out of jail. They're serving their time on bracelets for post-conviction. We're using it for pretrial. If somebody is multiple concern for the use of alcohol, also for domestic violence, as was just mentioned, we use it called active GPS, where a defendant is monitored 24/7. They have an exclusion zone they're not allowed to enter. And if they enter that zone, the machine starts beeping. It gets louder and louder and louder, so everyone around them knows it's going off. And with the advent of what Ronnie's talking about, if that victim has a phone, anywhere they go, they will be notified if an offender is getting into that zone. And we can't exclude the whole city of Bellingham or the whole county. People go to grocery stores, they go to schools, they go to different places. And so when each place that victim may go is not protected, this new device will be really helpful. We have, besides just the amount of social services that don't have to be used because somebody's still able to work, still able to go to school, still able to keep their children, still able to not lose their apartment or lose their government funding. It's just been such a powerful tool, not only for the jail, but I think for the services in our community, and doing the best we can to keep those services going and help them not to be interrupted. And we do use the SCRAM bracelet, the one for alcohol detection, quite a bit. And anecdotally, we've had people come to the court later and almost not want that bracelet off because it's been a reminder to help keep them accountable. But it's been effective for defendants also in that they're not having to report to probation for daily UAs or weekly UAs. Again, because they're being monitored, it frees them to remain in their jobs or home or wherever they need to be. So we have just found it to be invaluable in many ways. And we have worked with Friendship Diversion since 2016. They have a local office. Our defendants are just blocks away from us, so our defendants can walk over there, get their bracelets on. And so I think that as we as a group look at one of the solutions for keeping people out of jail, for those who are not a risk to the community, is just a wonderful way to do it. And it's so inexpensive. One day in jail for the first day when they pay a booking fee is over $300 now. If they're not paying the booking fee the initial day, it's still over $200. A bracelet is $14.50 a day. And so you can see the enormous financial savings as well as the benefits to the community. So we're very appreciative for the program, and it's just really been something that we've seen tremendously successful.
Thank you, Darlene. Ronnie, I'm sorry we lost you there for a minute, but I want to give you a chance to add anything else that might have come to mind.
Okay, I'm not sure what happened with my internet. It was just the perfect timing. I don't have anything further to add. But if there are any questions or if anybody wants to ever chat with me, I would be happy to do that.
Thank you so much. And thank you for being here, and thank you for the services you're providing in the community. Just to try to close the loop on the discussion about electronic home monitoring, looking now at agenda item 6. Dave or Jake, on Bruce's behalf, I'll just invite you to raise your hand, or John, if there's anything any of you want to add about Superior Court or District Court electronic home monitoring. Otherwise, I'll ask Chief Tank to provide any information he wants to add to Raylene's about blame in the small cities. And Chief Tank may not be available either. Sheriff Elfo wasn't on, Caleb was on earlier, so we don't have anybody from the sheriff or the jail. I guess we've heard as much about electronic home monitoring as we're going to for the morning. Jack, I'm going to turn this back to you to start the committee updates.
All right, thank you, Stephen. And thanks, everyone. I think we've all got a much better understanding of EHM, and thanks again to Ronnie with Friendship Development and everybody else that was here to Friendship Diversion, sorry, to be here to give us this information. I see your new signs too. I think you moved out of the old Bond building. I saw you over by the high school, so I hope that's a good location for you. And probably easier to park. All right. Moving into committee updates, I don't have my agenda in front of me, but I believe the first, no, I don't think the first one was steering committee. The first one is, here it is, the Joint Behavioral Health and Legal and Justice Systems Committees. So a report on that. This was regarding the September 20th meeting. So who would like to, I see several people that could kick this off that are chairs or co-chairs. Who would like to do that?
Well, I guess I could start.
I was hoping you or Arlene or something.
Because I'm looking and I saw Mike and Mark earlier, and I don't see them right now. But I can say
And
that
Raylene, if you aren't prepared, we can be somewhat informal. We have the minutes, so I think maybe the highlights and
that's great.
Great, just kind of
So,
high level.
2 presentations as I'm trying to go through my notes here because I had too many notes for today. But we had one from the Whatcom Community College Substance Use Disorder Professional Program. Tori Sandos from the Community College gave that presentation. And that was very helpful and educational. The notes should be in your packets. So I don't think I want to go over it more than what you can already do yourself, but there was an overview of job availability and wage expectation, which was definitely a concern with that program is we need more counselors, we need more people in the field, and the wage is too low to entice individuals to get into that program. So that was something that needed to be addressed. Eligibility requirements, there were education, experience, exam, and other requirements. They explained how prospective students could apply to the program. So if Arlene wants to add any more, or Dave might come on and want to join that. The other one was the Vanessa Beham Center. That was a presentation from Amy Myers, and she actually spoke about the program that's currently in Spokane. This is a child care drop-in center, unlike a licensed daycare center. It was a drop-in center for anybody that was involved in the criminal justice division. And that respects, if somebody that was to serve on jury duty didn't feel like they could because they didn't have childcare, that could be used for that. If somebody was meeting with their domestic violence victims advocate, they could drop their child off for that. If they had court, family law court, if they had criminal court, their child could be dropped off for that. If they had to do methadone treatment, children could be used for that program. So there were a lot of different avenues that this could be beneficial for all courts in the state of Washington, including Whatcom County. Eric Ritchie mentioned that there was a program they were working on trying to establish for this purposes in the criminal justice field, but it is definitely something that I think would be beneficial for our county to look at, specifically for maybe the Bellingham area, for individuals in all facets of the criminal justice program. Am I missing anything, Arlene? Does anybody else want to add to my recap? Unmute, please.
I'm trying to remember if the discussion about the new implementation of the probation department for domestic abuse offenders, was that in steering, or I think it might have been in our meeting, but it was very impressive, a hiring of a new counseling group to provide domestic DV offender treatment, a thorough program of treatment that is implemented by the probation department primarily. And I thought that that was really important, that because we've had a long period of a lack of treatment available. So it's something that's hopeful.
It definitely is. And I think sometimes all our meetings get jammed together. Jake did a brief presentation today about it. Phoenix Counseling is the new up and coming program that we do have in here,
Phoenix,
but we
yeah.
are using DV POTS and the DV-MRT program. The fascinating thing that I found was the moral recognition therapy. And that was making sure that defendants are being held accountable for their actions, and that their belief system has to change, which is a very difficult process to do. And Jake touched on that, both at the legal and justice and a little bit here today as well.
Right. The mentioning of the anger management program, which, you know, from a psychological point of view, is absolutely crucial to DV offenders having anything to do with changing behavior or changing belief systems. It's going to come a lot through individual therapy, but especially group therapy, where you have the open discussion amongst perpetrators of their experiences and why they do what they do. You know, it helps them a lot.
Agreed, Arlene. I think the big thing is we still need more treatment providers in the area. We need to entice more people to become mental health professionals. I think that was kind of an overview of the whole, the joint and the last meeting when it came to the DV discussion. But I think we're moving forward, not backwards. Thank you.
Does anyone have any questions? Okay. Seeing none, I'm going to go to the next agenda item, and then Stephen, if you want to take the legal and justice systems following the steering committee, that'd be great. And I guess after that, you can take us through the rest of the meeting if you don't mind. And with that, Barry, would you like to give a report, please, on the steering committee?
Yeah, sure, Jack. Thank you. We had two items that kind of fell outside the things I discussed today that were fairly significant. One was the Pyramid Communications gave kind of an update on their communications work that they're going to be doing for the task force. They had made some adjustments to some of the core messaging strategies that they had kind of presented earlier to the task force based on our feedback, and those got incorporated into their plan. So they talked a little bit about just basic overarching framing, primary messages and secondary messaging, and how to get that out to the public. One of the things they're very excited about is the kind of what they were calling their first piece of engagement or point of engagement, which is on the Crisis Stabilization Center. They think as we do all as well, it was one of our huge accomplishments that this task force has worked on over the years. So we have a great opportunity on as you may remember, the council officially approved the name change for that facility, and it's going to be called the Ann Deacon Center for Hope. We had planned to do a ceremony for that. Sometime earlier this year. We didn't get around to it because of all the activities going on, but right now we're trying to throw something together in what Pyramid is calling the Season of Hope, which fits the bill for the title of the new facility. And that's kind of that period between Thanksgiving and Christmas. So I'm working with Erica to try to get that in motion. I guess she has talked to Ann, and they've got a couple of maybe tentative dates. I'm not going to throw that out yet, but when we do, I just hope everybody will be able to attend. It's going to be a great ceremony to celebrate what we've done, some of the work we've done in our community. So look forward to that. The other thing we talked about was, as you recall, I talked earlier about the work that the BEGAT team did on looking at behavioral health gap analysis. And the next step in that work has been to really try to quantify what some of those resources that we would need to implement some of those ideas that are what we kind of call lacking in funding from the sequential intercept model, or programs needed and not in existence yet. So they are going to be working on that. I talked to Erica on Friday after our meeting on the Competency Workgroup, and she is excited about moving that forward. And so she's going to be working with her team to look at what some of those costs might be going forward. So those are kind of the two items that we talked about, other than our regular updates on the SAC, which I've already given. But that's it for the steering committee.
Okay, thank you very much, Barry. So Raylene and Arlene, we're back to you. The Legal and Justice System Subcommittee met on its own October 11th, and I know the materials are in the packet as well, but if you want to highlight anything there, please take a couple moments to do so.
I think we kind of covered it because we went over the DV POTS, the DVMRT, and that's what Jake presented on, and then the jury trials. Dave Reynolds presented today on Superior Court, and then I gave a brief overview of what Bruce discussed at our Legal and Justice Subcommittee. So unless, Arlene, you think I missed anything, I think we've already pretty much covered it.
Yes, I think you're correct. Yeah.
Okay, thank you both for your leadership on that. So moving down the agenda, we're at other business. The only thing I'm aware of is just a heads up to task force members. Tomorrow, the Behavioral Health Subcommittee meets in really interesting and timely focus. They have invited Representative Alicia Rule and Joe Valentine, the Executive Director for the North Sound Administrative Services Organization, the Regional Behavioral Health and Medicaid Coordinating Agency. They're going to discuss strategizing for how to advocate for better Medicaid reimbursement and provider rates for behavioral health and substance use disorder treatment services. And that links directly into the workforce issues that Raylene touched on out of the joint subcommittee meeting. So that will be the beginning of conversations locally that hopefully will spill into the legislative session. The steering committee hopes to continue that discussion afterwards by inviting legislators to our November meeting to look at ways that we can expand from our regional need and coordinate with other regions facing the same financing hurdles. So hopefully we'll get some concerted consensus advocacy going for the upcoming legislative session to address workforce issues and the expansion of needed services. Hope everybody can join that meeting or that discussion if you have the time and you're interested. Is there any other business that anyone wants to raise? I don't see any hands. Jill, can you ask for public comment, please?
Yes, thank you. It looks like we have 3 attendees. If any of you would like to speak to the task force, please virtually raise your hand now. For our phone caller, you can press *9. And no hands are raised.
Very well, thanks, Jill. And thank you all for joining us this morning and plowing through some pretty varying information. Again, Behavioral Health Committee meeting tomorrow morning, 9 o'clock. And I guess we'll see you all in November otherwise. Take care, everyone.